In this segment, I'm going to talk about the employment relationships. As I mentioned earlier, in order to satisfy the regulations, you have to have a petitioner, and a petitioner can be either an employment relationship or a U.S. agent relationship. If you have an employment relationship, then essentially what you're telling immigration is that the employer will pay you directly for your services. There are two different ways that people get paid in the United States. Some people are paid as a payrolled employee. If that's the case, they fill out a form called a W-4, and they get a W-2 at the end of the year. In this instance, taxes are withheld. So if you have a job at a design firm or an architecture firm, generally you will be an employee of that firm. And if you're an employee of that firm, and if you earn $1,000, taxes are withheld and you will get, say, $600 or something to that effect. Architects, museum curators are examples of people that have a direct employment relationship. The second way that people can pay you is as an independent contractor. And that is where the employer is paying a person for the service, but they're not technically a payroll employee. They're classified as an independent contractor, and that person has to pay their own taxes. So in the instance of an independent contractor, if an independent contractor does a job for an employer and they get paid $1,000, they will receive a check for $1,000 and they're going to be responsible for paying their own taxes. If they're an independent contractor, at the end of the year, the person who gives them the assignment is going to give them a form called a 1099. From my experience, USCIS is fine with documentation of either payroll employment or even documentation of someone who's paid as an independent contractor. There are additional laws called U.S. labor laws that can affect whether someone is legally classified as an independent contractor or an employee. So this is a bit of a complex issue, and someone should discuss this with an attorney, but from my experience, for the purposes of immigration, if you have an employment relationship, USCIS is fine if they are either an independent contractor or a payroll employee. An example of an independent contractor in a USCIS or an O-1 visa application would be a photographer who is petitioned to do a series of photo shoots. So you have someone who would be an employer, and that person commissions the photographer to do a series of photo shoots over a 3-year period, and that is something that USCIS can approve, and it's something by its nature, it's not going to be an employee of a person sitting in an office doing work. It's someone who's being paid for a specific task or a series of tasks, and in that case, they can be an independent contractor, but from the purposes of the O-1 petition, it can be what we call an employment-based relationship. There are a number of different types of employment relationships that are accepted in O-1 visa applications. You can have a full-time employment, you can have a part-time employment, you can be paid by the assignment, and that could be by the month, by the week, by the day, even by the hour. The important idea is that the employer has to specify what the terms are. So you cannot be vague and say, we intend to work with them in the future and we may give them some work. That's too vague. So USCIS is very flexible if you can account for all of the terms of the relationship. What are you going to do? Where are you going to do it? When are you going to do it? And how much are you going to be paid? And so ultimately, this is something that you have to discuss with your attorney. Another thing to keep in mind is that you can have multiple petitioners. So you can have an employer that petitions for you, and then you can have an additional employer that petitions for you, and that essentially rides on top of that visa application. We call that concurrent employment. So you can have, for example, if you're a designer and you work for a company, and then you want another company to give you some additional work, that additional company can petition you for part-time employment that can be concurrent with the other visa application. And so it's a very helpful tool in certain situations. There's two ways to add a petitioner. One way is the concurrent employment, where the employment essentially is parallel with the other employment, or something called change of employer, where the current petitioner supersedes the prior employer, and so at that point you're only being petitioned by the second employer. So the other thing to keep in mind, we're going to discuss a little bit later, is the U.S. agent relationship. And there are situations where you can have an employment relationship and you can actually add a U.S. agent to have additional assignments. And that's something that is really unique to the O-1 visa and really helpful so that people can do a lot of the things that they would like to do in this visa application. One last topic regarding the segment, the question of whether someone can self-petition. So the short answer is that a person cannot petition for themselves. The secondary question is, can a foreign national, someone who's from a different country, own a corporation or set up a corporation and then have that company petition for them? This is a bit of a complex issue. For many years, the law essentially said, or the regulation said, that if you had a corporation, that corporation was considered a separate legal entity from the person who was the owner. And because of that, it was separate, then the corporation could give that person a salary and petition for them. In subsequent years, on appeal, the Bureau of Immigration Affairs said that there has to be a relationship called a master-servant relationship. And this is a very old case that they found. And they essentially said, if you're the owner of a company, you may not have an actual employer. And if you don't have an employer, you don't qualify for an employment visa. On the other hand, there are situations where someone can be the owner of a company and they can be terminated or they can be fired, and then they do have someone who is serving as their employer in a sense. I'll give you an example of one of the few instances where a foreign national can own a corporation. If you have a startup, like a technology startup, that you own the majority of shares, you can sell your minority shares to an investment fund or some sort of board of directors. And under those circumstances, the alien can have a majority shares of a company, and that company can petition for that artist, because essentially the artist can be terminated. So if a board of directors can terminate a visa, then or terminate an employment relationship, then you essentially have an employment relationship even though that you're the owner. So again, it's a very complex issue. For the purposes of this segment, I would say most people cannot self-petition. There are a few people that probably could, and they would have to discuss this with their attorney.